Yes.
Or not, I've been instructed to take the withdrawal notice.
Learned advocate for the petitioner, by placing before this court the communication dated
I am only to withdraw the.
The learned advocate representing the petitioner on instructions would submit that no, the ওই আগেরটা ইন্টারি মডেল ইফ এনি স্ট্যান্ডস ব্রিগেডেড এটাও তাই আছে নেই এটাতে আছে একটা না নেই কিছু আগেরটা আছে ইয়েস
Lordship, I appear on behalf of the petitioner, Lordship.
Appear for the last contempt. Your Lordship had given direction to pay 1 lakh rupees. We have been only able to pay 25,000 because of insolvency fund.
Lordship, in the last order, Lordship, kindly see the submission is on behalf of the private respondent that 25,000 has been paid. That has never. The certificate officer has called me for a hearing saying that 25,000 has possibly been deposited and to collect that check.
We haven't been able to.
It was an erroneous submission.
Well, the consequences follow, madam.
Property has been attached by the bank. Property has been attached by the bank.
They have taken steps, Your Lordship. They have already attached my property.
Lordship, the certificate officer is the alleged contender, Lordship. Let a rule be issued, Lordship.
You released him.
On 16th April.
You were sleeping tight over the matter. Sleeping tight. Your officers were sleeping tight over the matter.
No, they were arrested, Your Lordship. Your Lordship had passed a.
Only after this court has intervened.
They were released on the condition that we will be paying 1 lakh rupees. They were arrested.
They have not complied with the condition. Let them remain behind the bars.
Lordship's order was passed 2 years, 3 months back, Lordship, on 19 January.
You tell me, what is your insult? Yes, Miss Monday, what will I do? Tell me.
Lordship, there is a rule be issued upon the certificate officer, Lordship.
What will the certificate officer do?
Lordship, they know how to do it.
No. Why a rule will be issued on certificate officer? What wrong
Lordship,
officer has done?
Lordship, he did not take any steps under section 14 of the Bengal Public Demand Recovery. Only after this honorable court directed.
You were also sleeping
That-
tight for the matter.
No, Lordship.
Thakur, Mr. Guo Thakurta, let us not go into things.
Lordship, page 14 of the application kindly sees, Lordship, immediately communicated.
Time to comply with the 1 lakh order. My mill has been closed for the past 8 to 9.
Ms. Pandey, learned advocate representing company representing Delta Limited on instructions would submit that she needs some more time to make payment of would submit that the company needs some more time to make payment of rupees 1 lakh in terms of the 1 lakh, 1 lakh. Now, Ms. Pandey, learned advocate appearing on behalf of the company, on behalf of Delta Limited, would submit that though it was submitted on 25th April 2025, that a sum of rupees 1 lakh shall be paid on or before 2nd May 2025. Such payment could not be made. She needs some more time to make such payment. Post of having regard thereto and considering the facts of the case, let this matter stand adjourned and appear in the month list of June. for Delta Limited to make the aforesaid payment as recorded in the order dated 25th April 2025.
Lordship, the 25,000 has also not been paid, Lordship, as recorded in that order. That also not been paid. Lordship, in the last order, it is recorded that Ms. Pandey submitted 25,000 already paid to me. That has never been paid.
Where have you filed an affidavit to that aspect? Challenge that.
Lordship, an erroneous submission made by an officer of the honorable court, Lordship.
Present on that date in court.
Yes,
Why
it was her submission. It was her submission. We had no instruction on that day, Lordship.
Mr. Guotakutta, I've recorded her submission in your presence. What were you doing?
Lordship, we had no instruction, Lordship. It was only her submission.
Yes,
we had no instruction.
Mr. Ghosh, he says that he has not been paid 25,000. No, Mr. Guotakutta would submit that the petitioner has not received 25,000 as recorded in the order dated. Agithin Kausha dao. As recorded in the order dated 25th April 2025. However, Mr. Ghosh, learned advocate representing the alleged contemner by placing before this court
I have been called today to take the check of rupees 25,000. That is,
by placing before, you ought to have taken instructions, proper instructions, by placing before the check issued in the name of the drawn on Federal Bank, would submit that the aforesaid check has been deposited by the company, by the directors of the company, by the company on 22nd April 2025 itself. So, a copy of the check and along with the covenant letter is enclosed herewith. Stop having regard to this the alleged contemner. It might be recorded that in future, Mr. Guotakutta should make submissions upon ascertaining actual state of affairs prevailing.
Lordship, let them show that I have been handed over the check. Let any of the alleged contemner or the private
was recorded, Mr. Guotakutta. It was recorded.
Yes.
You had paid
Yes.
the check. You are
not paid. Not paid. I have been called.
I have recorded it. Well, last line take it out.
Yes. But my lord, they had not handed over. Called me today to take the check of rupees 25,000.
Go and get the check from the authorities. Yes, call the next
Lordship, Lordship, Lordship.
I appear for the state respondents.
Yes.
My lord, in this matter,
what instructions do you have?
the instruction is that on the 4th July 2022, an order has been passed by which the proceedings has been transferred to NCLT. My lord, kindly have a look at this order, my lord, what has been handed over, my lord. And my lord, the order categorically indicates that with respect to the assets, no steps has yet been taken. My lord, kindly, if your lordship kindly comes to page 3, my lord, for once. Internal page 3 of this order. But it says that the official liquidator has also not taken any steps whatsoever to sell any of the assets of the company. So far we can ascertain that the assets are intact right now. And we have checked from the website that in the NCLT, till date only dates are being given, no effective steps has been taken as yet. So, my lord, if your lordship so desires, my lord, if your lordship grants us liberty, my lord, we may be added as a party over there in the NCLT.
No, why will I direct? You have to apply on your own.
My lord, we'll do, but as the matter is pending over here, my lord, we have to, my lord, because we have checked from each and every order of the website, from the website, there is no further steps after that. Since then, not yet any resolution professional or any none has been appointed till now. So we'll have to approach the NCLT only, my lord. And my lord, the effective portion of the order is at page 9. Page 9 middle.
What have you then done thereafter?
And my lord, it take to the na. It is pending before the NCLT that we have taken the latest status, my lord. My lord, then if your lordship, my lord, have a direction at least in this matter, my lord, we'll approach the NCLT, my lord. That is the only way out, and we'll be added as a party so that we may place this claim also over there.
I'm retaining the matter on the file for the time being. What I am doing is this. I'll record your submission and say that you take steps in the matter and come back to me after the vacation. Because this is the 23rd of April 2025. What happened?
Yes. Well, after that, my lord, the latest position is not with me, but this is no effective steps has been taken. Well, that we have checked. My lord, my learned junior has also taken
Today,
it from the
Mr.
record.
Ganguly, learned senior advocate representing the state respondents, has placed before this court
Hmm. এইটা কি? নোটিশ দিয়েছে।
Thereafter, show cause notice. That is on 14 December 2015. Thereafter, certificate issue on 7th of yes.
Eighteenth May, yes.
6th March হয়ে গেছে যে winding up was passed. The order of winding up was passed on 6th March.
Right.
এই যে second.
Hmm, hmm, hmm.
পরে আমি দিয়ে দেবো।
The order of winding up was passed on. Right.
winding up orderটা কি করে আনবে?
এটা একবার দেখতে হবে। Yes, because it says that on 6th March 2017, the winding up order was passed. So we'll have to check. I'll come back with that order itself. We'll try to. We'll have to get this order. We'll passed. Yes, we'll have to look into that. কিন্তু আমাদের ওটা কি এটা কবে হয়েছে? সার্টিফিকেট কবে হয়েছে বলছো?
17th of
মার্চের তো পরে এরপরে।
তো আমাদের winding up order পরে তো।
Certificate পড়ে হয়েছে
নোটিশটা গেছে। ওটাতে হবে না। সার্টিফিকেট ফর ডিলাইজেশন হচ্ছে এই দিনকে। এখানে বলছে সার্টিফিকেট issued under এত for payment of gratuity for এত mention আছে। এখানে তো ডেটটা বললো না। Copy of the findings with direction. 16 যদি হয় তাহলে হয়ে যাবে কাজ। দেখো তো আমাদের এভিডিভিটির মধ্যে রয়েছে কিনা। আমাদের দুটো এভিডিভিটি দেওয়া ছিল না। দেখো 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 ওর মধ্যে দেখো। এটা এইটা নোটিশ ফাইনাল অর্ডারটা কবে হলো? এটা কি দেখো তো।
Now I think compliance is required. Either section 7 or section 9.
চলো বসছি I'm grateful. I'm grateful.
Procedural my lord left that they can file the application under rule 11 of the IBC rule. They can approve. I think before that to file before the identification authority, directly liquidated to consider their claim because it is time barred. The claim now the claim. No, that is another, but there it has not been placed before the liquidation process.
That has to be considered. I'm obliged, my lord.
My application. My lord, this is my application for modification and or variation of your lordship's judgment dated
Justice Department of
Yes.
Reference.
Hmm.
Reference.
Yes.
My lord, I have got one judgment of Justice
No,
Newton by
recent-
Vijayanagar
rec-
by Justice Sanjeev Banerjee.
Recent
And the
judgment.
Apex Court judgment.
Recent judgment. No, let us consider the judgment, my lord. Come. Your lordship has it.
Okay. Well, you now adjourn the matter. I shall next.
Madam, Madam, I am filing my reply. My lord, my lord, I am relying on 1961 SCC online, Supreme Court 71. 61 SCC online, Supreme Court 71.
Yes.
Page 71. Mohan Ram Hassan. My lord, I am placing paragraph 5 and 6. My lord, my lord, then let us consider the judgment and come back, my lord.
2024.
5.
Yes, disciplinary proceeding cannot be continued beyond time limit set by courts.
Judgment আছে না এটা শুধু হেডিং থাকছে জাস্ট দ্য হেডিং
তাহলে রেফারেন্স ফাইল করে দিচ্ছি তো আগের দিন ফাইল করেছি তো। State of Uttar Pradesh versus Ram Prakash Singh. Justice Dipankar Datta Judge. Judgment has not been reported. Short করে লিখে নাও।
পাঠিয়ে দিচ্ছি ষাট 60 পেজেস Yes, well, 16.
Your Lordship
16,
directed
16
that
weeks.
this is finality.
16. Your Lordship directed to complete the.
After completion of 16 weeks time, the matter will be ended. No further reference. Lordship kindly count your
Within F16.
And 16 weeks,
My lord,
my lord has
my
already
lord,
expired.
let me place the facts, my lord.
16th August.
They took time, my lord, for 1 month. He was sick. The read petitioner was sick from 13th June to 4th July. We can complete the proceeding within that time.
My lord.
My lord, we have filed this. My lord, we have filed this application on 3rd July. My lord, we have filed this application on 3rd July. Your lordship directed
My lord,
to complete within 16 weeks. My lord, they have not communicated the order.
admitted that due to their delay. My lord, they admitted.
My lord, 16 weeks from. My lord, 16 weeks from the date of communication of the order, my lord. Here, my lord, they have not communicated the order. So I am taking it from 19th March. 19th March, 4 weeks means approximately within 13th July, something like that. 4 weeks. My lord, he was on sick leave when a read petitioner was on sick leave from 13th June to 4th July. He joined on 5th July. We have completed the proceeding on 24th August. 24th August we have completed. We have completed the proceeding on August. Order means the findings. But the findings I have annexed with my reply. Entire proceeding, disciplinary authority, entire proceeding means the findings of the inquiry officer. It was
No. Completion with passing the order of punishment.
Yes, my lord, it is completed. Punishment order. Punishment order. No, compulsory retirement.
4th September, they have given me show cause notice against the inquiry officer report.
Yes.
I am placing your lordship judgment.
But thereafter, justice rise. Justice rise.
I shall wait in July and I shall
It is cited. It is cited.
Yes, that's Supreme Court, my lord. No.
পাঠিয়েছো Yes, no পাঠিয়েছে মানে জাস্টিস দীপঙ্কর দত্ত আপনার citation একটু
My lord, I will have to go through the judgment.
সেটার জন্য টাইম
Only relevant portion. Lordship, I'll give you 1 week time then.
নেক্সট ফ্রাইডে তো ছুটি
Friday week there.
আপনার সাইটেশনটা একটু বলুন 109
I file my opposition also. Earlier occasion.
ও আমার না ইনেক্টিভ
I'm appearing on behalf of the petitioner. May it please, my lord. My lord, two applications, an application for restoration and an application for condonation of delay. My lord, what had happened is during the COVID era, the advocate on record, the erstwhile advocate on record, he was not, he was non-communicado. The petitioner, he was non-communicado. The petitioner had tried to get in touch with the AOR, but then there was no communication. I am the petitioner. No, I'm representing the petitioner, my lord. No, my lord. No, my lord. The erstwhile advocate on record. My lord, thereafter, when the matter was dismissed for default, the petitioner was communicated from the Central Excise and Service Taxes Tribunal regarding an appeal. So this particular petitioner is connected to the appeal that has been filed out there. So they were asked to. My lord, the Wakalatnama has already been filed with it.
No, Lordship, I have asked to ask for no objections, but client didn't communicate with the Australian advocate, so that's why
No, my lord.
client.
The client
Not-
tried
not
to
even
establish
tried.
communication, my lord. The advocate on record to this date remains non-communicado. He has not responded in it.
Yes, Lordship.
Yes, my lord. Yes,
Yes, Lordship. With the department.
My lord, the filing. My lord, the filing number is 64903 of 1. Here are the copies.
I'm Amit Kumar Rai.
court of law is also simple.
I tell them your
What is the client will be, and you change the advocate and put someone without indicating the right. But he has to provide basis of communication that he got right.
It's not the-
Big steps in the managing emergency law. Any sufficiency and then come big steps and the letter to the previous advocate may not advise us.
Lordship, I am appearing for the applicant, Lordship.
My Lordship, in this matter, Mr. Robi Kumar Dubey is appearing for the petitioner. My Lordship, he's not well. That's why he cannot come to the court today.
Lordship, if she is
No, I'm-
here,
For an adjournment.
Lordship, I am praying for a modification on the compliance of order passed by Honorable Division Bench, Lordship. It is very clear. He has nothing to say, Lordship. Actually, modification of Lordship's order. There has been, Lordship, let me show. Lordship, kindly comes to page 14, Lordship, of my application. Lordship, from paragraph 12 onwards, the only other issue which falls for consideration in the present application is the date from which the applicant would be entitled to the last drawn wages. I find that the present writ petition was filed on 17th March 2023, although the award has been passed on 29th of November 2022, Lordship. But in paragraph 14, Lordship has also held that the last drawn wages to be paid from the date of award, Lordship. Lordship has held. But Lordship, in paragraph 16, the writ petition, paragraph 16, Lordship, page 17. The writ petitioner is thus directed to make payment of the last drawn wages respondent one applicant determined as aforesaid from 3rd of January, that is from implementation of the. Yes, Lordship. But Lordship has held. But Lordship, Lordship has held that from the date of award, Lordship. No, Lordship, no, Lordship. The date of award means from the date on which it was passed, Lordship. Lordship. But date of award and notification are different dates, Lordship. Yes, Lordship. Yes, Lordship. It does not. This is 17B. Lordship, this is 17B, Lordship. Yes, Lordship. Let Mr. Dubey come, Lordship. Let Mr. Dubey come, Lordship. I don't have. COVID মধ্যে জয়েন করবে কিছু বলেছে? We had Lordship. Lordship, that period, that disputed period. Lordship, Lordship. Yes, Lordship. Yes, Lordship. I will also show Lordship the order of honorable division bench on that day. On that day, Lordship. On that day, I will show Lordship. All the no, Lordship had considered judgments and no, no. Only clarification. Lordship. Appeal court has made clear, Lordship. I will show on the next date, Lordship. Let him come. No. Lordship. On that day, I will show. Let Mr. Dubey come. I will say something. Something I will say. Yes, Lordship. Yes, Lordship. Great.
Lordship. Lordship, in this matter, we have decided to withdraw the petition, Lordship. We are going for the amnesty scheme, Lordship, under section 128.
আমি কি করে জানবো আমার কোন মামলা আছে 1209 But in Lordship's order, Lordship had expressed that date of the award.
But division bench judgment is from the date of the award. In our division bench judgment. Not publication, from the date of the award. In previous occasion, we used to get that from the date during the pendency, from the filing of the writ petition. Yes, your Lordship has passed it. Yes, already. Yes.
The matter is already heard, I mean, in part.
Because I am for the petition, contempt petition.
Lord, we have already deposited the amount in terms with the order passed by the division.
Lord, only
Now the
Lord,
yes, it is already heard in part. Lord,
no appeal court. The writ court.
Original writ court.
Lord, in the contempt proceedings, two parts is there. One is for execution of the order and one for the punishment. Lord, so far as per the division bench order, they have deposited the amount. And 2 months only the stay order was there by the division. 2 months. For a period of 2 months, contempt proceedings shall be stayed. And or until further order which
Lordship, I have mentioned.
Lord, clear. Order is very clear. Order is very clear.
entire amount. That is execution part. So far as the the in yes. Only that earlier part. Earlier part. Look, the entire amount has been deposited by the yes. Look, so far as the punishment is, kindly see the order. Whether the page 6 of the division bench order. Page 6, middle portion. In the event the appellate petitioner deposit the entire amount within the aforesaid stipulated period, then no coercive action shall be taken against the appellant petitioner for 2 months or till decision of the writ petition. Whichever is earlier. Whichever is earlier. Yes. Or 2 months or yes. Only I am. Not. That's why I indicated. If you go, it's not a deal. Otherwise, I will have to proceed. He is saying, what will I proceed with this matter? The earlier person we were and then yes. Whatever be your money can never be taken by us. Cannot be taken. Subsequent petition also cannot be taken. Trying to be hard to cannot be taken back. So therefore, this matter is secure. Therefore, no input is a the application, the money goes to him. Post the application, the money goes to him. That is clear. Money goes to him under all circumstances. The money goes to him. You lose, the money goes to him. So, your lordship of order but that's only 70 last not pages, but that has been done in the petition. No, it is a case. That is the law. Lordship, it is. I'm not giving. So, my money is should be secure. So, if you win, money goes free. Lose, money goes free. Under all was this contempt proceeding is pending. Yes. Yes. as per Supreme Court judgments. CA Panchayat Raj, CM Panchayat. That's three conditions. Sir. Get
much obliged.
Well, the remaining that is cash compensation. I'll find out. Yes, they are saying that I am not the regular employee. That is why.
Direction. I've served my lord by 120. My lord, copy of the affidavit has been not. But we have specifically stated, my lord. As to the, my lord asked the question as to the provident fund payment. Lord, I filed it just now. Just now I filed.
Futures, bonds. Three category ration money not given.
Lord, ad hoc bonus. Lord, ad hoc bonus means if employee who works for 6 months, my lord, he is given some bonuses. 6 months in a year. In any year, if an employee, if any person works for more than 6 months a year, he is given some bonus amount. So that amount, my lord, is given who actually works for him. As to the PF, we have stated, my lord, that he is not entitled to it. No, because in case of an old pension scheme, it is only payable in case of new pension scheme. Lord, no employees having old pension scheme has been given employer share of provident fund. That has been stated on note in paragraph. Lord, he was directed, he retired before the order was passed. Lord, and in the old,
Lord, kindly come to page 34 of my content.
Lord, 1 minute, Lord.
Yes, page 34 of my content.
It was under the old pension scheme. Miller.
But paragraph 36.
Respondents could be. All the employees that have been Millard, all below. No employees having old pension scheme have stated. Lord, in his case, tax offer was
the other income. That part. Whatever benefits others have got, shall also be. But that I understand this. Like, because the client says something, I understand. And says, oh, old pension scheme nobody is getting. Correct? But are the employees correct? Are the pension scheme
Lord, that I have to inquire and come back.
No, my lord.
Ad hoc
We
bonus
have
have
not given, because
not
I
have
am,
given a direction to come up with what is would be the calculation. And that calculation we have to. He is not entitled. Because he has not.
And recognize the exact period, but treating he has got. How can he say he has not got?
Lord, question me, Lord.
What does that mean? You are prevented, you are got it. So you have to give all consequential benefits. You cannot say you are got it, you are not get the salary. No.
Salary is not a dispute we have given. Lord, consequential bonus, my lord, will adjudicate, but consequential as to the bonuses. My lord, I cannot deny parent order is there. That has not been challenged in the question, my lord.
no.
My lord, as to the my lord, whether all had been given the option of choosing old or new, that I inquire from.
Providence Fund. And employer's contribution towards the Providence Fund.
First of all, my lord, I humbly submit there is no violation, because we have given, my lord, what we could understand from. My lord, Dinesh Singh Thomas, the Senior Divisional Security Commissioner. I think Tomar is the contender, one of the contender. Yes, my lord. Is most probably one of the contenders. Dinesh Singh Tomar is two. Lord, kindly note that we have filed the affidavit that in terms of.
No.
Lordship, I am for the petition.
Your Lordship, she was to appear only today, but her network was not working, so I was legs in court 36. No, Your Lordship, she was only to appear. She said that her network is not working, so she asked me. I had a matter in court 36. Your Lordship.
Lordship's order dated 13th of December 2023, not complied.
Your Lordship, 97,529 has been paid out of the total amount, Your Lordship, and the remaining amount that is due is 1,37,033. It is remaining due as of now, Your Lordship. We have made payment of 97,000 plus amount, Your Lordship. Financial condition, I have advised them, we are in a process of filing a writ that before a court, taking installment as it had happened in before Your Lordship, when Your Lordship was taking a matter, that before the registrar, the money is deposited. From that, all workers are paid in a installment wise, so that
No.
These were the different matters. We are taking
That
Mercy Ghosh matters and these matters. That was reference to Provident Fund, Your Lordship. They have been paid fully.
That matter paid, Lordship.
Your Lordship. Your Lordship. It was in reference to Provident Fund. Your Lordship. Your Lordship. Your Lordship. This is not that person, Your Lordship. That is not. We are taking steps to file a writ application wherein
And sleep in. Sleep.
Within 31st March, quite often.
Your Lordship. I appear for the company. They are within the directors, Your Lordship.
একটা কপি দাও না কপি দিতে কি এগুলো জমিয়ে রেখে করবেটা কি
Your Lordship, because of our financial condition, we have not been able to pay, Your Lordship. But we are not running away from our liability, Your Lordship. Your Lordship. Your Lordship.
All of the
Subroto Nashkar. I'll get it, Your Lordship. Lordship, June to July sometime. Your Lordship. Your Lordship, for that I have to take instructions for the undertaking, Your Lordship.
Director, was submitted to the certificate officer also. What year have you crossed?
Your Lordship, I'm getting the father's name. Meantime, I have handed over the names.
It will appear on Lordship. Yes, Lordship. Lordship, it will appear on 15th of July, Lordship. Wait.
Anamika appeared. Your Lordship. Your Lordship. Lordship, that is a direction. Whether they are obliged undertake or not, that is after that law will take its course. Your Lordship. Your Lordship. Sincerely grateful.
One of the next two matters, because my senior Mr. Kaur is leading, he is in larger bench, and Somo also.
Mr. Mohiuddin is on his legs, my lord.
Because Mr.
My lord, only
Yeah, before
my let
vacation there is no
it
test.
in the list, my lord.
Yes,
monthly
yes.
list.
Well, kindly pass one line order. Grateful.
No, I appear on behalf of this.
Yes. Yes. Continue. Mr. Dutt, all records are here.
That?
Records?
Not all records are here. Records are
Yes, continue.
records. Are
Well, this is the case of impersonation. In spite of qualifying and my lord, test, he has qualified both in the physical test, written test, and oral test, and has secured more marks as a scheduled caste candidate, but he was delisted. His name was not empaneled on the ground for impersonation. Basically, my lord, the identical matter was considered by the Honorable High Court as Rajasthan. Same and identical matter.
I remember you showed me that, Judge.
Yes, yes. You also kindly come to the judgment, my lord, I have annexed. Page 38. You also kindly come to page 39. I have gone through the order passed by the coordinate bench in the case of Ramesh Kumar Puri and others versus Union of India and others. This court, while relying on another judgment of this court in Anil Kumar versus Union of India, civil appeal number has decided on 9 March 2017, passed the following order. Accordingly, I find that this disposition deserves to be allowed in terms of the judgment passed by the coordinate bench in the case of Anil Kumar, which this is under. The present petitioner has been filed under Article 226 of the Constitution of India, praying that a writ in the nature of mandamus be issued and respondent be directed to issue appointment letter in favor of the petitioner, and furthermore, action of the respondent to cancel the examination of the petitioner be set aside. Admittedly, the petitioner, in pursuance of the employment notice number 1/11 issued by Indian Railway, applied for the recruitment as constable in Railway Protection Force. The petitioner was allocated for roll number. The petitioner had taken written examination. The petitioner also passed physical efficiency test, and thereafter he appeared in the interview. Same thing in my case. Mr. P.C. Sharma, the learned counsel for the respondent railway, has submitted a letter on the department learned that copying at large scale had taken place, and certain candidates had taken examination by way of impersonation. The learned counsel for the respondent contended that the definitive information was received by the department that candidates arranged highly qualified person to appear in the place in the examination and impersonation had taken place. The learned counsel for the respondent has contended that in order to restore the sanctity and the purity of the examination, some impression of the application form and answer sheet were got compared from the fingerprint expert. The learned counsel to the respondent appearing for the railways further submitted that fingerprint expert opined that the thumb impression on the application form and on the owner sheet were different. Thus, the candidature of the petitioner was cancelled and the criminal prosecution case has launched. Mr. Hem Singh Rathod, the learned counsel for the petitioner, has contended that though investigation was carried by the police and investigation agency came to conclusion that there is no evidence to prosecute the petitioner. It is contended that the investigation agency had also sent application form of the petitioner and the answer sheet for verification, and it was concluded that there is no evidence available to send the petitioner for trial. This court had passed the following order. SHO Police Station, Sadar, Jaipur City, is directed to produce the report of the forensic science expert obtained by him from the forensic science laboratory regarding the comparison of specimen thumb impression of the petitioner and the thumb impression appended by the petitioner on the Omar sheet and the application form released on such a Sunday. Mr. Sanjay Kumar Sharma, Government Counsel, is directed to ensure presence of the investigation officer of case FIR number Sasansa, Sadar, Jaipur City, along with record on the date fixed. Copy of this order be handed over to Mr. Sanjay Kumar Sharma, Government Counsel, under the seal and signature of the court master for onward transmission necessary compliance. In pursuance of the said order, Mr. Sanjay Sharma, Learned Government Counsel, through ASI, Mr. Rameshwar Police Station, Sadar, Jaipur City, had produced before this court the report of the finger expert from the Forensic Science Laboratory, Jaipur. The said report co-petitioner reads as follows. Disputed thumbprint Q43 alleged to be of Anil Kumar, son of Visharam Meena, is unfit for comparison, being masked and lacking in a sufficient number of clear, rich details. Note admitted thumbprints marked A100, A101, and A102 of Anil Kumar, son of such and such, are similar or identical with the own personal left thumb impression such and such. The Learned Counsel for the petitioner has submitted that the answer sheet contains the thumb impression of the petitioner as per the report of expert. It is further submitted that at the time of physical efficiency test and their interview, thumb impression of the petitioner are also obtained. It is submitted that thumb impression on ownership and document prepared at the time of physical efficiency test and interview tally. The Learned Counsel for the petitioner does submit that it stands conclusively proof that it is petitioner who had undertaken the written examination, physical efficiency test, and the interview. The Learned Counsel for the petitioner submits that admittal is signature of the answer sheet, attendance sheet at the time of physical efficiency test and interview contain thumb impression of the petitioner, and it is confirmed by the fingerprint expert. The assertion.
Yes, I have read it.
Now, my lord, the
finding is because it was smudged, it cannot be said it is not his. That is the case. Now, what is their opposition? What is their opposition here? What they have said?
My lord, let's kindly the concluding portion. Page 41. After hearing the Learned Counsel,
you read this merely because the thumb impression of the applicant form.
There is no doubt that it is petitioner who had undertaken the written examination and appeared in the physical efficiency test, and he had also appeared in the interview. Same thing is done. Merely because of the thumb impression on the applicant form is masked, the petitioner cannot be ousted from the selection process. It is good for the respondent to adhere to the highest standard in a recruitment of the employment, but the respondent cannot be asked to deny employment to rightful claimant. Merely because thumb impression is masked on the applicant form and is a doubt has been cast, the petitioner cannot be ousted from the selection process. Thus, the respondent, without application of mind, had denied employment to the petitioner. At this stage, unable to dislodge the argument raised by the Learned Counsel for the petitioner, that it is the petitioner who had appeared in the written examination and succeeded on merit, the Learned Counsel for the respondent railways has raised hyper-technical objections. Merit has to prevail. Merit has to be signed. Therefore, less meritorious person have to make way for meritorious person. Consequently, the present disposition is allowed. Respondents are directed to issue appointment letter in favor of the petitioner to enable him to join his service. The petitioner shall be online entitled to notional benefits of the joining. Identical, my lord. The petitioner is identical with this petitioner in the judgment. Everything is identical. Petitioner filed the writ petition before the Rajasthan High Court along with them, but as there is no jurisdiction, on the point of jurisdiction, Rajasthan High Court did not entertain the writ petition. That is why petitioner filed the writ petition before this honorable. But same and identical, everything is same.
Let me find out what they have said in the written affidavit in opposition.
Not only that, what is the result of the criminal case? What is the report of the?
I'll come to that. What is the opposition? What they have said? Actually, very well, they will indicate. Yes, Mr. Dotto.
My lord, first of all, I challenge very much the maintainability of this application. The grounds of maintainability, what I have challenged is, my lord.
Fine, final hearing. You do along with that maintainability, I will hear. After
Let me
affidavit,
clear, my lord.
after affidavit is not a case of demurrer. You answer me and then you answer the due. Today, it's no longer a question of demurrer that you should have taken at the first date. Today, after affidavits, I'll go through the documents and consider. As an ancillary issue, I'll take into consideration the point of maintainability.
Yes,
But you answer the points.
The question is, my lord, it is there in case of the judgment which has been shown, my lord. There is a
So forget the judgment. What have you stated in your opposition?
opposition. I have stated, my lord, that we have found it to be an impersonation. We have complained against this 2%, including other 84%, including this 2%. We have made a complaint before the police for the purpose.
What happened thereafter?
My lord, last year, police has given us information, my lord. This is a written information obtained from the police, my lord, which speaks of, my lord, they are still investigating into the matter. That is the report, my lord, which police has provided
After
us.
so many years, still investigation is going on.
My lord, that is what the police has stated, my lord.
So you have not followed up this with the
My lord,
police.
what more can a railway protection?
Naturally, you ought to have done. Yes, very well. Where is your report? Where is the report? Keep it.
Report is here, my lord. I'm fine.
This
is a report, my lord. This is a report, my lord, wherein our own fingerprint expert has come out that the fingerprints are not identical.
Show me.
This is the two reports, my lord. One is of Gisaram, the other is of Shivcharan Meena. This is the two reports, which speaks of that they are not identical, which has been also been annexed with their writ petition, my lord. That copy is there, my lord, that they have all annexed with the writ petition itself.
Not the report of the forensic laboratory expert.
Correct.
Yes, they are fingerprint experts of the railway. In the panel, they are fingerprints expert. Their designation is fingerprint expert. Railway has kept this for the purpose. And they are the fingerprints expert. They are expert in the field and they have given the report.
Have you taken any report from the forensic laboratory? Had called for all records to be produced?
We have not gone to the forensic library. We are thereafter approached the police and filed a complaint. There, let them investigate.
No, are you sure?
Milord?
Because the previous order records, the order delivered by the Rajasthan High Court records that it was sent for forensic examination.
It was a case which was referred to, Milord, is respect of other cases which it was referred. It was following Gisaram Meena. In Gisaram Meena, some other case was referred, Milord.
Let's find out. Let's find out.
Milord, what I could understand is that it was referred some other case which was referred by them before the court that reflects of those cases wherein, Milord, the Honorable Court observed it. Here, Milord, I have gone through the judgment of Anil Kumar versus Union of India and others. That is maybe identical, but not it is exactly for Gisaram Meena and Shivcharan.
So in this case, the police did not investigate.
Milord, they are investigating. As I have given the
nothing. What is the investigation? What is the status of the investigation?
Milord, they are still investigating.
What after 4 years?
Milord, that is what the police has stated.
Where is your complaint?
Huh?
Where is
Milord,
your
complaint has been annexed with the affidavit in opposition.
Yes, show me that.
Milord, that is the annexures. Milord, the complaint is there. Officer in charge has state police station.
So far as your document is concerned, you cannot be judge of your own cause.
Milord, that because
it's a very serious, it's a very serious issue.
Milord, obviously serious issue. We have taken also serious steps in the matter. That is that what has been annexed with our affidavit in opposition. Their complaint.
Where is your which page?
Milord, the one R1, Milord. Milord, they are there. Affidavit in opposition and these two persons' name, Milord, Shivcharan Meena is at 80 and Gisaram Meena is at 81. The last page, page 18. Have you Lordship point of page 18? Shivcharan Meena and Gisaram. That is a question of impersonation. And secondly, my lord, I would also take the point of maintainability.
You simply see that sent it to the police without proceeding further in the matter. Where is the 91 pages annexure? Yes. Where is the annexure? Where is the complete document? Page R1. There are 91 pages of page R1. Where is that? Your records is there. Show me the records.
That was, my lord, all the fingerprints of these persons were deposited with.
I want to see what is there. Show me. I've directed you to produce the entire records.
91 pages. You know that handwritings, but they have also annexed.
No, I have asked you to produce the entire records. Where is the records?
Pages दिया था वो है. The last occasion as of an impression, my lord, that as
Go through the order on the last occasion.
my lord, I have, but
the entire records are available, not readily available.
lord, the
Paragraph 3 of the order, very clear.
but as you know, the impression goes as to this, what we have done as to the after that.
11th, the 8th of November 2024.
My lord is there, but really the impression.
It is not that easy, Mr. Dotto, that you can say records have not come today.
My lord, record I have the original.
Entire records were required to be produced. On the last occasion also, this particular fingerprint records were there. The entire records were not available before this court.
Original, my lord, this original was not there on the last occasion. My lord directed that.
Only these few pages are with you.
My lord,
Only these few entire case records. This is
my
the
lord,
entire
in
case
respect
record.
of these two persons, that the complaint has been made, their OMR sheet, that the complaint, their medical examination.
Show me their OMR sheet.
Is the OMR sheet. OMR sheet, there is no, this is the OMR sheet. This is the OMR sheet. The percentage is not a dispute, my lord. This is the OMR sheet. In both cases, two files are there, my lord. In both of them, this one is the first one of Shivcharan Meena. Shivcharan Meena. This one is of OMR sheet of Shivcharan Meena. And this one, my lord, is of Gisharam Meena.
I'll get this examined. Very clear.
Lord, let them appear and that would suffice.
Yes, yes.
Yes, that would suffice.
The fingerprints are very clear.
Oh,
Malak, this is not the forensic laboratory fingerprint expert opinion.
I will get it from forensic lab. I will get it from forensic lab. Is your client ready?
Yes, ma'am.
my lord, if this does not match and for this harassment, they has to be penalized. If it does, will
You have already suffered an order in the other matter. So that is the reason why I will call for. He will pay for it.
And my lord, one more thing, my lord, I would also press upon before my lord as to the maintainability of this case. This is not maintainable.
Okay.
This case is not maintainable.
So you
That
are ready
case
and
was
willing?
different. That was, there was no
You are
maintenance.
ready and willing, sir? Are you ready and willing to bear the cost? Take instructions, I'll put it to be mentioned on another date.
Lord, one
Wait, sir, why are you so apprehensive? Now let the petitioner take the call, whether they are willing. Yes.
Cost for forensic laboratory expert.
Forensic laboratory. National, you give me the name of the forensic laboratory here. Yes, yes, there is a laboratory. They will do the fingerprint and they'll come back. Yes, yes, everything is available. All documents are there and nothing is smudged. Not a single document is smudged. Absolutely clear. And he will also provide his fingerprint before the authorities.
With his identity.
With his actually.
Yes, with his identity, the finger.
And picture is there. His photo identity is there.
So it will come up.
Take instructions.
And
The respondent has produced the relevant records, including the OMR sheet of entire, I will record it. You have to bear the entire costs and expenses for this.
That can be recorded.
রাইটার দিয়ে দাও, the costs ওখানে আগের প্যারাগ্রাফে দিয়ে দেবে, the costs for carrying out the aforesaid investigation through the Central Forensic investigation. Nothing. The records are available with you.
Police does not
So
take
don't
we
part
don't
with the
have-
records. In the meantime, don't part with the records.
No, no, no. পুলিশকে দেবে না, চাইলেও পুলিশকে দেবে না।
Don't part because of,
We will not. I've instructed.
next. Point. And this matter, either way, whichever way it goes, on the basis of the fingerprint records, I will decide it.
That would be, we'll have the best clearer picture. Obviously, we'll
And everything is so clear in this. All the documents are available with you.
yes. And our fingerprint experts have given a report. Most probably they do not
He's
have any
challenging the
enemy
same. He's
against
challenging.
any of them.
He's challenging the same. Yes, call the next matter. Mr. Mojumdar, your junior has taken an adjournment in this matter.
The other matter, my lord, is, but here, my lord, I'm led by the learned AG, my lord, he is out of forum.
This is being adjourned every day.
But I tell you, there are two sets of petitions. That one at the instance of the workers and one at the instance of the management.
Now complete it. I have adjourned it on too many occasions.
What's the tricky situation? That the workers have challenged the prohibition notification under Section 10 of the Contract Labor Act.
I've challenged it.
It's a unique feature.
Workers have challenged it.
After sales judgment, not previously, Air India Statutory Corporation Limited allowed automatic absorption on issuance of a notification under Section 10. Now, SAIL had overturned that judgment with a rider that the consequence of a notification issued under Section 10 is not automatic absorption and
no further appointment.
And only the workers will have a preferential right in a process of appointment. So when this notification under Section 10 of the Act was issued by the Union of India, directing abolition of contract labor system in the particular process, the principal employer had issued a notice directing the contractor to go along with its men and materials.
I'll hear it today.
As a result thereof, the contract laborers were facing a
Sir,
loss of
Mojumdar will
employment.
argue the matter. Mr. Advocate General will come. When he comes on the next date, I'll hear it. But I think, Mr. Mojumdar, it will be continuing after that 2 p.m. matter. I'll take your matter. I remember this has been adjourned on too many occasions. There is no opportunity to Mr. Mojumdar even start the matter.
Not both of us not are challenging the same notification.
I know, I remember this, but come at 2.
দুটোর সময় থাকবে না তো?
Some means I have a fixed matter.
Yes, then some of that next week we can come. Next week is a holiday, the week next.
Then in June. You don't want to do the matter in
No,
June.
I am here, but Mr.
I remember too many occasions that.
But your lordship will be hearing it in piecemeal. That's why if Mr. Dotto has
No,
to submit.
It will never be completed in one day. You also know, Mr. Mojumdar. It will take time. You will be showing me judgments. So somewhere down the lines, you have to start. Unless you think that a judge is capable of retaining it only for a particular date, whatever he hears. Apart from that, I have to hear you.
Yes,
You will be taking some time, I think. You will be taking at least an hour.
30 to 40 minutes.
40 minutes you will take. Then I'll hear Mr. Advocate General. Then you give in reply. So it cannot be concluded in one day. Very well. On the prayer of the learned advocates representing the parties, let this matter stand adjourned and appear in the month list of June. But in clear that I will not.
Come on the list of dates, that will be shortening the length of the.
Come and finish these matters.
I am filing.
These are What you see, these are the assigned matters.
Lord, when the interim order was passed, please have a look at the interim order.
I passed it.
Justice Topension as his lordship then was.
And actually, 2011, আর কার কার কাছে গেছে আমার কাছে date
It's interim order dated. No, your lordship is looking at
matter went up to Supreme Court.
Please have a look at 5108 W of 2011. Order sheet of 5108 W of 2011.
Yes. এই অর্ডারটা দিতে হবে না আজকে বোথ পার্টিজ অ্যাডজমেন্ট চাইছে দিতে হবে না পড়ে থাক পরে থেকে মান্থলি করে দাও
My lord, in this case, my lord, I am finding my affidavit in opposition.
Keep it
behalf of
with
the
you.
Union of Indian Law.
Keep it with you. No, Justice Devashish Korgupta passed an interim order. Oh, interim order already passed shall continue. Pension. সরে আছে অর্ডারটা কোথায় এতে অর্ডারটা নেই
Maybe 20th September 2011. 20, I'm sorry, 24th March 2011. 24th March 2011.
Yes, I've got it. No, 24th March is issue notice. Prairie. Yes, Prairie. Justice Sen, Topen Sen. Not Somen Sen.
No, Justice Topension as his lordship then was.
Oh. That is stayed. That is continuing.
Then IOCL also independently challenged because they were facing.
Nobody preferred an appeal from this order. Everyone is so happy. You are for the workers.
I'm for the writ petitioner in this workers' writ petition and the respondent trade union in IOCL's writ petition.
And what is your case? What is your contention?
My lord, first, earlier, my lord, a order was passed that prohibition of the contract labor is not required. Thereafter, my lord, it has been changed, and the now the order has been passed. It is required, but the change, my lord, it's based on no material. No, what additional material was considered for changing the opinion? That is the whole point involved.
And in the same process, through the advisory process of the Contract Central Advisory Board, the government of India initially decided that it does not warrant a prohibition. Then after several rounds of litigation before this Honorable Court, they decided to review it. Now the review order is prohibition of contract.
He is challenging it, I understand. Why are you challenging it?
Well, it is.
No, why are you challenging it? You want to continue with contract labor?
But this will create a huge anomaly in the industry, my lord. All these persons, my lord, will be terminated. Industrial unrest will give rise to industrial unrest, and the functioning of the refinery itself will be stalled.
তাহলে ওই অর্ডারটা থাক পার্টিরা দি চাইছে অ্যাডজার্নমেন্ট দিয়ে দাও You want in July?
No. But this is the first case of its nature.
Argue it. Mr. Mojumdar, somewhere down the line you have to argue.
But I'll have to argue, I understand. the reservation must percolate to the base level. And in fact, in the other matter which your lordship had taken up, not the hotly contested matter, the previous one. No, there I find I checked it up with I compared that with the list. It was there. So I checked it up. Yes. After that observation, I checked it up. I compared. I found that it was there in the other list. Yes, of course. Yes. That was a division bench judgment. No, it's not that it cannot do. Matter we may not give our attention to a particular provision. But in course of argument, the learned advocate for the other side pointed out a particular provision in the regulation which had not occurred to at the time of drafting the writ petition might be. Yes, it may crop up.
Fixed, should be fixed.
List item number 5.
Your Lordship, may I? Lordship, on the last occasion, Mr. Shah had distinguished 1979 to SCC codes. Now, Your Lordship, I'll begin, Your Lordship, from distinguishing the judgment which was relied on 1997, Volume 3, SCC 398. And just give me a moment. No, no. Just a minute. No, submission to, okay, no, I got it. No, the judgment, sorry, Your Lordship.
Yes, you want to rely on which judgment?
No, Lordship, the judgment which was
97
relied on by them, 1997, 3 SCC
Yes.
398.
Yes.
Now, if Your Lordship will see that that judgment, Your Lordship, was passed while considering a case of Customs Tariff Act,
Yes.
which is a beneficial legislation. The proposition in that case was that the applicability of promissory estoppel against the government hinged upon the balance of equity or public interest. I'll just show the paragraphs which they had relied on. And court has to determine. Your Lordship?
3, 4. They started with
Yes,
3, 4,
3,
7.
4, and 7. I'll come to those paragraphs. I'm just giving Your Lordship that. And court has to determine whether the government should be exempted from the liability of public interest. DVC has not been able to establish that. Now I'll show just that. If Your Lordship kindly takes paragraph 3, 4, and 7, which was relied by them. Paragraph 3, if Your Lordship takes, it is not necessary for us to go into the historical analysis of the case law relating to promissory estoppel against the government. Suffice it to say that the principle of promissory estoppel is applicable against the government. But in case there is a supervening public equity, the government would be allowed to change its stand. It would then be able to withdraw from representation made by it, which induce persons to take certain steps which may have gone adverse to the interest of such persons on account of such withdrawal. However, the court must satisfy that itself that such a public interest exists. Then, Your Lordship, a reliance on a judgment has been there. Now, if Your Lordship takes paragraph 4, two propositions follow from the above analysis. The determination of applicability of promissory estoppel against public authority hinges upon balance of equity or public interest. It is a court which has to determine whether the government should be held exempt from the liability of the promise or representation. In the present case, the first notification exempting the customs duty on PVC itself recites central government being satisfied that it is necessary in public interest to do so. In the notification issue letter which gave rise to the present cause of action, the same recitation is present. Now, if Your Lordship will kindly take paragraph 7, which they had relied upon. No, I'll come back. I'm just showing the paragraphs which they had relied.
Yes.
The next question is whether the fact that the notification mentioned the period during which it was to remain in force would make any difference to the situation. In other words, could it be said that an exemption notified without specifying the period within which the exemption would remain in force would be withdrawn in public interest, but not the one in which the period has been so specified? Once public interest is accepted as a superior equity which can override individual equity, the principle should be applicable even in cases where a period has been indicated. The government is competent to resile from a promise even if there is no manifest public interest involved, provided, of course, no one is put in any adverse situation which cannot be rectified. To adopt the line of reasoning of so and so, it may still be within the competence of the government to resile from the promise on
This
giving
line.
reasonable notice.
This line.
Yes, I'll just
That
read it.
no one be put to adverse situation which cannot be rectified.
Yes, now I'll come to this, Your Lordship. I'll come to this. Now, to adopt the line of reasoning in so and so, it may still be within the competence of the government to resile from the promise on giving reasonable notice, which need not be a formal notice, giving the promisee a reasonable opportunity of resuming his position, provided and kindly a reasonable opportunity of resuming his position, provided, of course, it is possible for the promisee to restore the status quo ante. If, however, the promisee cannot resume, the promisee would become final and irrevocable. Now, if your lordship will kindly take paragraph 6 once. They have not relied upon. I'm showing your lordship paragraph 6. It can be seen that in the High Court, in the case of Bombay conductors, had also noticed a similar public interest in withdrawing the notification of exemption. The appellants in the present case have not disclosed any facts which could show the existence of better equity in their favor. Following this, your lordship will find the paragraph 7. So now if your lordship takes the writ petitioner.
Proposition is of law is based on facts. Without facts, it cannot proceed. That is all right.
Trying to show your lordship is that if your lordship sees here, your lordship, this fly ash, your lordship, which I had showed your lordship, if your lordship remembers in the very beginning, a chart. Now, what are they doing? Today, they have an agreement with me.
That is the distinguishing feature.
Yes.
Of your...
No, that's why I'm trying to distinguish on this fact that in this matter, if your lordship will see, there are 2 or 3 facts which your lordships will have to take into consideration. Today, the agreement which we have, which was later modified in January 2019, 6 rupees we were paying towards the administrative charge. Now, they say that we have to go towards e-auction. Now, your lordship will find that this fly ash is also going to the ash pond. And they are spending...
How long will you take? Just indicate Mr. Sen is waiting. Just how long will you take?
Your lordship, time will take some time. Oh, sir is waiting.
Not be taken up. North Bengal. North Bengal. I'll give priority because this is on the verge of conclusion. Not be taken up.
Why I've showed paragraph 6 is your lordship.
Sitting here, waiting here, that's right. Indicate. Yes.
Paragraph 6, why I showed your lordship that the appellants in the present case have not disclosed any facts which could show the existence of better equity in their favor. Now, your lordship, what I am submitting to your lordship is that today DVC is incurring expenditure which is more than 90 crores in just the transportation cost in evacuating that posh act. And not only that, your lordship, because of that ash pond, there is health hazard. And your lordship, I would also like to indicate to your lordship that there is an order of NGT. There is an order, your lordship, also of the NGT under which they had to pay a heavy compensation. Because of the health hazard, around what amount was paid? 20 crores, 14, more than 14 crores. So today, a entity who has an existing contract for which they don't have to pay the transportation, for which this party is itself paying the transportation cost, plus 6 rupees, they have not terminated the contract. But they are not supplying as per the contract. In fact, they're choosing to put that in the ash pond. If it is hazardous to others, they are fine with it, but they are not complying. So there's the equity, then your lordship will see the equity is in whose favor. I could have understood, your lordship, if they would have said that this has become a valuable commodity. Now there are so many buyers that they are not able to supply to the buyers who have come through e-auction. That's not their case.
Only difficulty is e-auction is taking place.
Yes.
So, but if e-auction was not taking place, you see, it would have been easier for me to decide.
Then may I indicate to your lordship?
No, I remember. I have that chart is with me. Mr. Ghosh had called for that charge. Mr. Ghosh has disclosed the charge. What was surplus in their hands? I remember. But fact remains there is an e-auction.
Your Lordship, I'll just indicate them.
Yes.
Apropos this.
I remember that chart. That
Lordship, not
surplus
only
was
this.
available at their
This
hands,
e-auction-
which was required to be transported out.
E-auction started in 2017. In 2017. E-auction started in 2017 itself.
And 2019, I remember.
And my agreement is in 2019, which was modified.
Change and now they're saying notifications 2019.
So there can't be any change. I could have understood you have entered into the agreement. There was a change in law. No.
But you are only seeking for a declaration.
In fact, Your Lordship, we said if the press.
That is what
C,
Mr. Shah said on the last occasion.
Press C, we said, right?
Yes, yes.
Press C.
B and C.
B and C.
I remember, yes.
If Your Lordship is. So the question is, Your Lordship, I could have understood if the e-auction was prior. It's not that after they entered into an agreement in 2019, thereafter the e-auction came in. In fact, if Your Lordship takes the prayer, I think Your Lordship, subject to correction,
yes.
Mr. Shah did the issue a writ and or in the nature of mandamus entail quashing and or setting aside the letter dated July 19 and to direct the respondent and each of their men agents to continue supply of fly ash. And paragraph
C.
I read B. Prayer B and prayer E. Issue a writ and or in the nature of mandamus commanding the respondent authority and or their men, servants and agents to forthwith commence supply of dry fly ash to the petitioner in terms of the agreement dated 1st April 2009 and 1st January 2019 and for the balance term thereof.
It was his submission that petitioner seeks declaration that grounds of suspension are bad. And they are obliged to supply.
If Your Lordship sees press C once.
Yes,
In issue a writ and or in the nature of mandamus restraining the respondent from men from giving effect to or further effect to the letter dated July 19. I think this that will also suffice, Your Lordship. The press.
Just a minute, that is very
yes, kindly. Because Your Lordship, on the last occasion, I was there for some time and thereafter actually I wasn't there. So maybe I have. E and E, I think, Your Lordship.
Just a minute. Yes.
Now, Your Lordship, this 19th July letter also. This is not a letter by, it is when we complain to them that what's wrong, you're not supplying to me. Then this letter comes in.
Specific performance.
If
he is in the nature of specific performance.
Your Lordship is on the declaration. Oh, the A, the dispensation.
E. Directing them to supply. Mandamus. E. So you are seeking, I understand you are seeking C. And not only C, in addition to that, a declaration to that effect. That you are entitled to that supply. Correct? No. Because very important. I'll be recording that.
What I want to say is in
recording.
other way, if I can.
Whichever way you tell me, I'll record it that way.
What I am saying, Your Lordship, is that if Your Lordship takes one's press C.
Yes.
I'm saying that they should not give effect to this letter dated July 19. So if that July 19 letter is not given effect to, they will have to supply me.
Try and understand, madam. Assuming I give this declaration, please understand.
Yes.
This is a declaration. Can I enforce that? Tomorrow they do not comply and do not supply you.
I'll have another cause of action.
Correct.
I'll have.
I will not be in a position to enforce that. Because they might say, did not direct supply. What you said that this is not to be, I do not know what they will say then. But it becomes difficult for the court to enforce such a prayer.
I will once, Your Lordship,
Yes, yes,
take
yes,
Your Lordship to that letter of July 9th.
I remember that letter of July. I remember. Both of you have shown me. I remember that. I've seen the paper.
May I show that
Today
letter to
only
Your Lordship
take-
in
no,
my own way?
I want to only understand this much, madam. What relief after the arguments are over now? The arguments are really over now.
going to
Exactly what
distinguish
relief,
that and maybe
accepting
we'll show.
distinguishing,
Yes.
which you will, I answer.
Yes.
What exact relief are you seeking from this court?
C, E, to C. I think, Your Lordship, if we get C,
I'll be recording that.
E by way of abundant caution, but C is the one.
E you are not seeking. You are not seeking. C you are seeking.
Your
Yes.
Lordship is putting me in a
C.
difficult. C
No,
is.
you are, madam. You know your case best. You know what you can get.
Actually, if
and-
Your Lordship sees.
No, petitioner can place so many things, but at the end of the day, you are aware what can be granted and what cannot be granted. So you are seeking C.
As far as what I am understanding, Your
Very.
Lordship's observation is in respect.
No, I did not make any observation. I am only considering both of your submissions. B and C.
B and C.
Very well. Can I record that? No, not now.
Not
means-
now. Not now. Don't record it now.
No, I will not record it here. But I have to record that in my judgment. I'm not going to record anything here.
Can you just give me a moment?
Yes, because this is what I'm going to ultimately record. Because that line, that judgment you showed.
Yes, I understand what is troubling Your Lordship. That last 3-4 lines of that paragraph 7.
So I want to know, what are you seeking from this court? Very well. I take it and proceed, man. Otherwise, it will not conclude. Today, we have to
If
conclude.
Your
this.
Lordship once.
You may place that judgment once again. I will take it here. I will go through the judgment once
Yes.
again.
So what I was placing before Your Lordship was that if Your Lordship takes paragraph 6, there
No,
Your
I'll
Lordship.
I'll come back to that judgment, but this is it. B and C. With regard to this, I'll read this judgment.
Yes.
B and C. Fair enough.
B and C. Your Lordship, the
Now,
3 submissions which I'll make Your
now
Lordship in
show me the
respect.
judgment once again.
Yes. That was 1997.
Yes.
Yes.
Paragraph 6 you want to place. You place from
Yes.
paragraph 6 again.
Yes. I'll again place. So if Your Lordship, my learned friend relied on paragraph 3, 4 and 7.
They relied on 7. 6
7.
you are placing. And
Yes. Now, if Your Lordship takes paragraph 6, it can be seen that the High Court in the case of Bombay conductors has also noticed a similar public interest in withdrawing the notification of exemption. So, note public interest. The appellants in the present case have not disclosed any facts which could show the existence of better equity in their favor. All that they have alleged that they would not have imported the PVC resin without the exemption, as that would have been unviable and uneconomical, and further that many persons took full advantage of the exemption. Moreover, the exemption accorded preferential treatment to some persons but not to the appellants. The facts of the economic situation explained in the judgment have not been controverted, nor is it alleged that the appellants at public interest did not call for supersession of the notification number 66. Now, Your Lordship, few facts, Your Lordship, which would distinguish this entire judgment would be: the first thing is, Your Lordship, that we have shown the facts which will show, Your Lordship, the existence of better equity in our favor. Secondly, when it comes to the public interest, in fact, not supplying us, Your Lordship, is in a way, indirect way, if Your Lordship will see, it's going against the public interest. Because the fly ash, the amount they are spending on transporting and evacuating that fly ash is far, far more than what they are getting out of that e-auction. They have not been able to sell that ash through e-auction. It's only a very small part which they have been.
I'm recording the submission. That DTC is incurring huge expenditure on account
Absolutely.
of removal of
I'll
light.
just give your lordship the page numbers
No, no,
from
I
the writ
remember that.
petition also.
And the chart disclosed by Mr. Ghosh,
Itself shows
that is enough.
that how much is lying. And in fact, your lordship, in our writ petition also, your lordship, we have shown, well, yearly, we have shown 3 or 4 years together how much they have
To
spent.
that Mr. Ghosh responded on taking instructions, means he brought it.
Yes. Now, if your lordship sees that, not only that, your lordship, this fly ash is a health hazard.
Just explain to me this line, come to this paragraph. The government is competent to decide from the province, even if there is no manifest public interest involved, provided, of course, no one is put to any adverse situation which cannot be rectified.
Yes.
This is the line, was stressed by Mr. Ghosh also, and you have also shown me this line.
The government is coming from a promise, even if there is no manifest public interest involved, provided, of course, no one is put in any adverse situation which cannot be rectified. Now, the question is, your lordship, whether this position can be actually.
I do not want to go
No,
into
it
that.
cannot be. That's what I'm trying to say, your lordship. It cannot be. Today, your lordship, that's why, your lordship, I submitted
Really?
before your lordship. The e-auction started in 2017 itself. So it is not the case, your lordship, that after they entered into an agreement with me, thereafter the e-auction started. In fact, your lordship, from 2009, they were permitted to sell that fly ash. And
By passage of time, things change.
no, lordship. That's why I showed. That's why I showed.
You agreed and you entered into a revised contract.
Yes, 2019.
That is nice. You can't go back so far. So you have entered into a revised contract up to 1,000 metric tons. This particular and beyond that.
More than that, then I have to pay as per the e-auction rate. So this was
you'll match the auction.
Absolutely. So as the limit which I have to get by paying 6 rupees towards the administrative charges, and I am paying my own transportation.
Yes.
So they are not incurring anything. I am paying my own transportation plus rupees 6 also. And in fact, your lordship, the notifications which came, your lordship, subsequently also, those notifications were very clear that the existing agreements, it does not apply to existing agreements. And in fact, the government also filed an affidavit to that effect before the NGT.
Very well. Next judgment.
So the next judgment next was 2012. No? The next one was, your lordship, 2012. 10 SCC 1.
This is the natural resources.
Yes.
Yes.
Now, this was a judgment, your lordship, which was passed in a petition. There was a presidential reference.
Yes.
If your lordship will kindly first take now 54 Natar Age started the questions. No, the judgment where it began.
Paragraphs, they showed paragraphs 157 onwards. 157, 158, 183, 184, 185, 186.
107, 119, 120, 157, 158, 183, 184. If your lordship will kindly come to first. Page 54. If your lordship will come to page 54, where your lordship, they've summarized the questions. The last paragraph. Now, therefore, in exercise of powers conferred upon me by clause 1 of
Yes,
article,
which paragraph?
sorry, page 54.
Page 54.
Page 54.
Yes.
Correct? I mean, which one is 54? This is 54. Your Lordship has that?
No.
Paragraph, page 54? Yes.
Page 54 is there.
The,
Which paragraph?
the last one, Your Lordship.
The tribunal has, no.
No, Lordship. Now, therefore, in exercise of powers, is it there? नहीं तो ये क्या, ये हमारा भी तो page 54 है।
SCC online page.
Your Lordship has the SCC online one?
Yes.
That's page 54.
The Supreme
Page
Court 2012, 10 SCC, page 1.
Yes, and I'm on page 54, Your Lordship.
Placitum,
Lordship is the last paragraph in that. It's not Placitum.
the last paragraph is paragraph 40. The tribunal ruled. Then before that is Kaveri 2. Then before that 38 at the outset. Then before that is principal objection.
Your Lordship promise, can I just have a look at maybe the...
I think it'll be page 41 in the SCC.
No.
No. Page 54 is the no. Just a minute, where it begins from.
No.
Page 41, they wrote page 40. Yeah. The pages won't be matching, huh? Oh, page 41. Page 41.
Page 4040.
41. So I think the page number.
It's not tallying with the SCC online. Strange.
SCC online has a separate.
Actually, Your Lordship, SCC online has a separate on the top the page number.
Yes.
So I was reading from there, but I.
No, you are reading the SCC online version. No.
Yes, I'm reading from SCC online only.
Then why is it not telling?
So there is a. It's not a true copy. I think that's a true copy.
Oh.
Here I find the page 41 in between. It has come in between. So I think I have to read these pages.
That your tablet is providing that particular page.
No, Lordship, 41 is also given, but in the middle of it. But on the top, the page what we're showing is page 54. If
Yes,
the Lordship takes that page 41, the
I've got it. Now therefore.
Yes. Now therefore, in exercise of powers.
Just a minute. I know. Let me.
I'm sorry. Yes.
Yes.
Now, if your Lordship sees, now therefore in exercise of powers conferred upon me by clause 1 of Article 143, I so and so, hereby refer the following question to the Supreme Court of India for consideration and report thereon, namely. Now, Lordship will find what were the questions were, whether the only permissible method for disposal of all natural resources across all sectors in all circumstances is by the conduct of auctions, whether a broad proposition of law that only the rate or route of auctions can be restored to for disposal of natural resources does not run contrary to several judgments of the Supreme Court, including those of the larger benches. Question 3, whether the enunciation of broad principle, even though expressed as a matter of constitutional law, does not really amount to formulation of a policy and has the effect of unsettling policy decisions formulated and approaches taken by various successive governments over the years for valid considerations, including lack of public resources and the need to resort to innovative and different approaches for the development of various sectors. What is the permissible scope for interference by courts with policy making by the government, including methods for disposal of natural resources? Whether the court holds within the permissible scope of judicial review that a policy is flawed, the court not obliged to take into account investments made under the said policy, including investment? Question 6, if the answers to the aforesaid questions lead to an affirmation, then the following questions may arise. Whether the judgment is required to be given retrospective step as to unsettle all licenses issued and 2G spectrum allocated in and after 1994 and prior to. So these were the questions, Your Lordship. Which were Your Lordship?
Concerned with the question number 1.
The natural resources.
Whether you want to
now,
go that
now,
far?
Now
to argue this far?
No, I'm not. I'm saying when they have relied on this judgment, the paragraphs, this was dealing with natural resources.
Yeah, I understand that.
So that is
you want to argue this far in this matter that natural resource.
What I am trying to show is
not a natural resource.
What I'm trying to say is the judgment which they have. This can't be. This has been known to be a hazardous. So it can't be a natural resources, at least. So the judgment cannot apply in this facts. That's why I showed the question. It was
Interesting
regarding.
way to distinguish a judgment, I must say. Novel way. No, that is lawyers for. You see, you get the time, you go through the papers and then you assist the court to come to a conclusion. But still then, you need to go through the entirety of the judgment.
Yes, I have, Your Lordship. So now, Your Lordship, the point which is considered here is regarding the natural resources. And I'm sure my learned friend is not calling fly ash.
Got it.
Natural. It's a hazardous. Now, Your Lordship, the judgments which were cited, Your Lordship, the next one was.
No, you don't want to go into the paragraphs.
Huh? I'll show the paragraphs.
No, not necessary. Very well. No, I'm just noted.
Because those paragraphs which they have shown, that's why, Your Lordship, I said that this is not applicable because this was regarding the e-auction in case of where there's a question of natural resources.
So more or less you have concluded.
There are few more judgments, 3 more judgments which they have. That was on difference between the treatment of public and private property.
Yes, Mr. Ghosh should have been here to hear this submission of his. Just missed
So
out.
they had argued, Your Lordship, that the fly ash is not a private property and its disposal is for augmentation of revenue, and state is under an obligation to secure the best market price available in the market economy. So a welfare state should make attempts to dispose of property at the best available price, because greater the revenue, greater the welfare activities get shot in the arm. So the judgments which were cited, Your Lordship, were 1985, 3 SCC 267. Paragraph 12 and 14 was cited.
Yes.
Kindly give me a moment. It is 1985. So, Your Lordship, if Your Lordship will kindly just once. Can you take the paragraph 3 once? They had relied on paragraph 12 and 14. Kindly just have a look at paragraph 3.
Yes.
The factual metrics first. The state of Haryana, in exercise of the power conferred upon it by Haryana Minor Minerals Act 1973, grant lease for winning minor mineral vesting in it. The grant of the lease is regulated by Punjab Minor Mineral Concession Rules 1964 in the application to the state of Haryana. A notification was issued on December 26, 1980, specifying that minor mineral quarries at various places in Faridabad district would be auctioned on February 20, 1981. At the auction held on that day, appellant Ryam and Sham Company gave the highest bid for Sarai Khwaja plot number 2 in the amount of rupees so and so. The presiding officer conducting the auction accepted the bid, but the state government did not confirm the same. A fresh auction was notified to be held on so and so. So the appellant participated and gave the bid for the same plot, his highest bid rising to rupees so and so for a period of 3 years. The same routine was followed. The presiding officer accepted the bid and the state government declined to confirm the same. Then there happened something which cannot have any parallel precedent in constitutional democracy like ours, but one should have profitably drawn parallel from the administrator of old princely state. Respondent number 4 wrote a letter addressed to the chief minister, setting out therein the history of various auctions and casting serious aspersions on those who participated in the auction. Inter alia, saying that the bidders at the auctions have formed a syndicate and want to monopolize the business by not outbidding each other, so that the state gets uneconomical rent, royalty. It was further alleged that the gundas and anti-social elements are assisting those monopolist bidders and successfully pushed out a party like respondent number 4. The letter further proceeds to take an offer that if the contract for a period of 5 years is given to the respondent number 4 in respect of so and so, it is willing to pay higher. There is also an offer for this and this with which we are not concerned. Promptly, this offer was accepted by the Chief Minister. The appellant challenged the action of the Chief Minister in writ petition in the Punjab and Haryana High Court, inter alia contending that those who formed the firm style so and so had participated in the auction and then made false allegations against the appellant, whose bid was the highest, and without giving him any opportunity, the offer of the respondent number 4 was accepted, which has denied equality of opportunity to the appellant in the matter of distribution. So this were the facts, Your Lordship, in which this judgment was passed. If Your Lordship now kindly takes paragraph 12 and 14, which my learned friend has relied upon. So there they say, let us put into focus the clearly demarcated approach that distinguishes the use and disposal of private property and socialist property. Owner of private property may deal with it in any manner he likes without causing injury to anyone else. But the socialist, or if that word is jarring to some, the community or further the public property has to be dealt with for public purpose and in the public interest. The marked difference lies in this, that while the owner of private property may have a number of considerations which may permit him to dispose of his property for a song, on the other hand, disposal of public property partakes the character of a trust in that in its disposal there should be nothing hanky-panky, and that it must be done at the best price so that larger revenue coming into the coffers of the state administration would serve public purpose. That is, the welfare state may be able to expand its beneficent activities by the availability of larger funds. This is subject to one important limitation, that socialist property may be disposed at a price lower than the market price or even for a token price to achieve some defined constitutionally recognized public purpose. One such being to achieve the goal set out in part 4, but where disposal is for augmentation of revenue and nothing else, the state is under an obligation to secure the best market price available in the market economy. An owner of a private property need not auction it, nor is he bound to dispose it or at a current market price. Factors such as personal attachment or affinity, kinship, empathy, religious sentiment, or limiting the choice to whom he may be willing to sell may permit him to sell the property at a song and without demo. A welfare state, as the owner of the public property, had no such freedom while disposing of the public property. A welfare state exists for the largest good of the largest number, more so when it proclaims to be a socialist state dedicated to eradication of poverty. All its attempts must be to obtain the best available price while disposing of its property, because the greater the revenue, the welfare activities will get a fillip and shot in the arm. Financial constraint may weaken the tempo of activities. Such an approach serves the larger public purpose of expanding welfare activities, primarily for which the Constitution envisages the setting up of a welfare state. And in this connection, we may properly refer to so and so judgment. And then if Your Lordship will kindly come to this one was, and then kindly come to paragraph 14 now. What happened in this case must open the eyes both of the government as well as the people at large, how an uncontrolled exercise of executive power to deal with socialist property, in which entire community's interest was sacrificed so as to cause huge loss to the public exchequer, would have gone unnoticed but for the vigilance of the appellant, who no doubt is not altruistic in its approach, but its business interest goaded it to expose the unsavory deal, considering that on weighty and valid consideration, the highest bid can be rejected by the state. On one such consideration which can be foreseen is that the highest bid does not represent the adequate market price of the concession. Yet before giving up the auction process and accepting a private bid secretly offered, the authority must be satisfied that such an offer, if given in open, would not be outmatched by the highest bidder. In the absence of such satisfaction, acceptance of an offer secretly made and sought to be substantiated on the allegations without the verification of the truth, which was not undertaken, would certainly amount to arbitrary action in the matter of distribution of state largesse, which by the decision of this court is impermissible, even though repeatedly this court has said that the state is not bound to accept the highest bid. This proposition of law has to be read subject to the observation that it can be rejected on relevant and valid considerations, one such being that the concession is to be given to a weaker section of the society who would not outbid the highest bidder. In the absence of it, the approach must be as clearly laid down by the Constitution bench of this court in so and so. In that case, the appellant and the fourth respondent were rival liquor contractors for the sale of the liquor contract for the year so and so. The contract was auctioned by the Deputy Commissioner under the authority conferred upon him by the Mysore Excise Act. The appellant's bid was the highest and the contract was knocked down in his favor subject to formal confirmation by the Deputy Commissioner. So the fourth respondent was present at the auction but did not bid. Instead of that, he went direct to the Excise Commissioner and made the highest offer. The Excise Commissioner cancelled the sale in favor of the appellant and directed the Deputy Commissioner to take action under the relevant rule. The latter accepted the tender of the respondent. The appellant moved the High Court for a writ of mandamus, which was dismissed. In appeal by the certificate, it was urged on behalf of the state that the Deputy Commissioner acted within the ambit of his powers under the relevant rule, which gave him an absolute discretion either to re-auction or to act otherwise, and no fetters are placed upon the otherwise method. The court negatived this contention, observing that the arbitrary improvisation of an ad hoc procedure to meet the exigencies of particular case is ruled out. Therefore, the grant of the contract to the fourth respondent was wrong. Repelling the contention that the writ petition at the instance of the appellant would not be maintainable, the Constitution bench observed as under. The next question is whether the appellant can complain of this by way of a writ. In our opinion, he could have done so in an ordinary case. The appellant is interested in these contexts and has a right under the laws of the state to receive the same treatment and be given the same chance as anybody else. Here we have Thimappa, who was present at the auction and who did not bid. Not that it would make any difference if he had, nor the fact remains that he made no attempt to outbid the appellant. If he had done so, it is evident that the appellant would have raised his own bid. The procedure of tender was not open here because there was no notification, and the furtive method adopted of setting a matter of this moment behind the back of those interested and anxious to compete is unjustified. Apart from all else, that in itself would be in this case have resulted in a loss to the state, because as we have said, the mere fact that the appellant had pursued this writ with such vigor shows that he would have bid higher. But deeper considerations are also at stake, namely the elimination of favoritism and nepotism and corruption. Not that we suggest that occurred here, but to permit what has occurred in this case would leave the door wide open to the very evils which his legislature in its wisdom had endeavored to avoid. All that is part and parcel of the policy of the legislature. None of it can be ignored. We would therefore in the ordinary course have given the appellant the writ he seeks, but owing to the time which this matter has taken to reach us, the consequence of which the appellant is in no way to blame, for he has done all he could to have an early hearing. There's barely a fortnight of the contract left to go. We were told that the excise year for the contract expires early in June. A writ would therefore be ineffective, and it is not our practice to issue meaningless writs. We must dismiss this appeal and leave the appellant content with an enunciation of the law. So facts of the two cases are alike, but if one attempts to compare the situation, the conclusion is inescapable. Appellant's bid was the highest bid. It was in the amount of so and so. Respondent number 4 approached the Chief Minister with a slightly higher bid. This was granted without any reference to the appellant to raise his bid. Such a thing, if allowed to pass once, is bound to be repeated because this method is open to the abuse of favoritism and nepotism and the loss. So now if your lordship sees the fact of this case, it's completely different, your lordship. Here, your lordship, the letter was written to the chief minister, the other person's bid was accepted. So here the question, your lordship, if your lordship sees the present case, your lordship. Here, your lordship, what is happening is, your lordship, an existing agreement, they are agreeable to incur huge expenditure, but not act in terms of that agreement, your lordship. And this is not this agreement.
Cancel this.
They have not even terminated that agreement also.
Yes, not terminated.
They have not even terminated the agreement, but they are not even supplying. When I put this point to them, then on 19 July 2022, they issue that letter saying that you amend, and then that is what has happened in this. So this, if your lordship sees the fact, this was on a completely different. Now, your lordship, the next was 1984 SCC 1. Para 14 they were. If your lordship sees, in that they had relied on paragraph 14.
Yes.
Where any government action falls to satisfy the test. Can you So, your lordship says para 14, where any government action fails to satisfy the test of reasonableness and public interest discussed above, and is found to be wanting in the quality of reasonableness or lacking in the element of public interest, it would be liable to be struck down as invalid. It must follow as a necessary corollary from this proposition that the government cannot act in a manner which would benefit a private party at the cost of the state. Such an action would be both unreasonable and contrary to public interest. The government therefore cannot, for example, give a contract or sell or lease out its property for a consideration less than the highest that can be obtained for it, unless, of course, there are other considerations which render it reasonable and in public interest to do so. Such consideration may be that some directive principle is sought to be advanced or implemented, or that the contract or the property is given not with a view to earning revenue, but for the purpose of carrying out a welfare scheme for the benefit of a particular group or section of people deserving it, or that the person who has offered a higher consideration is not otherwise fit to be given the contract or the property. We have referred to these considerations only illustratively, for there may be an infinite variety of considerations which may have to be taken into account by the government in formulating its policies, and it is on a total evaluation of various considerations which have weighed with the government in taking a particular action that the court would have to decide whether the action of the government is reasonable and in public interest. But one basic principle which must guide the court in arriving at its determination on the question is that there is always a presumption that the governmental action is reasonable and in public interest, and it is for the party challenging its validity to show that it is wanting in reasonableness or is not informed with public interest. This burden is heavy one and has to be discharged to the satisfaction of the court. Can I just give I just lost it.
Yes.
But one basic
Satisfaction of
principle.
the court by proper and adequate material.
Kindly just give me a minute. The government is reasonable in the public interest and is for the party challenging its validity to show that it is wanting in reasonableness or not informed with public interest. This burden is a heavy one and it has to be discharged to the satisfaction of the court by proper and adequate material. The court cannot lightly assume that the action taken by the government is unreasonable or without public interest, because, as we said above, there are a large number of policy considerations which must necessarily weigh with the government in taking action, and therefore the court would not strike down governmental action as invalid on this ground unless it is clearly satisfied that the action is unreasonable or not in public interest. But where it is so satisfied, it will be the plainest duty of the court under the Constitution to invalidate the government action. This is one of the most important functions of the court and also one of the most essential for preservation of the rule of law. It is imperative in a democracy governed by the rule of law that governmental action must be kept within the limits of the law, and if there is any transgression, this court must be ready to condemn it. It is matter of historical experience that there is a tendency in every government to assume more and more powers, and since it is not an uncommon phenomenon in some countries that the legislative check is getting diluted, it is left to the court as the only other reviewing authority under the Constitution to be increasingly vigilant to ensure observance with the rule of law. And in this task, the court must not finish or falter. It may be pointed out that this ground of invalidity, namely that the government action is unreasonable or lacking in the quality of public interest, is different from that of malafide, though it may in the given case furnish evidence of malafides. I'm not disputing this. Now, if your lordship will kindly take paragraph 17. If you kindly take 17. The argument under this head of challenge was that the state had, under the impugned order, granted tapping contract to the second respondent on terms which were highly disadvantageous to the state and involved considerable loss of revenue to the government exchequer. The petitioner contended that the price of resin realized at the auction held in December was so and so in 1979, and it rose to so and so at the auction held on so. But despite this phenomenally high price, which could have been obtained in auction, the state chose to sell resin to the second respondent at a lower price under the impugned order, conferring huge benefit on the second respondent at the cost of government exchequer. The impugned order therefore said the petitioner was wholly arbitrary, unreasonable, and contrary to public interest, and was liable to be struck down as invalid. This argument, plausible though it may seem at first blush, is in our opinion not well founded. Or closer look at the facts will clearly show it cannot be sustained. Then kindly take paragraph 19.
I know.
19. I'll show.
Original side, I've concluded now. I'm original side also.
Oh, I'm so sorry.
Because today there's only half an hour for the original side.
Any date, your lordship, I'll come
again.
Because your lordship, I have to show two judgments, your lordship, on the concluded contract, and I will just distinguish one judgment is left of. If your lordship, I'll just paragraph 19. I'll just.
No, you finish it on that because there is an original side. You see.
Very well. Then your lordship will kindly give. I'll just take.
They are suffering. Original
I'll just take
the most. Because usually I take it at 3. Most of the days I cannot take it up 3. I take it up 3.
No, I completely. Kindly give me 15 minutes more on the next day. That's it. Kindly.
Concluded your arguments, really.
No, I just showed two judgments, Your
To
Lordship,
show two judgments.
on the concluded contract.
And give it to him, share it with him so that
Yeah,
he
we'll
comes.
share it. We will share it with Mr. Ghosh. No,
I know that.
we'll be coming on it. Your Lordship will just give
Let me
15
know.
minutes. On the next day, we'll be over.
Not 50, only those two judgments. The rest, everything you have showed, only two judgments.
Very well.
No,
One judgment.
Otherwise, I can't
Very well.
If you don't want to conclude on this side of the vacation, then I'll be happy. I'll take it up in June.
No, I will be.
Then I'll take it up in June.
Yes.
Because you see, it's very difficult.
Your Lordship, what I'll do, give the judgment right now here also. And no, just five.
I'll fix it in June. I'll fix it in June in that case.
Kindly give it in May. I
don't know. I live in a position to take up in May.
I'll try to finish it in 10 minutes.
I'll have to give a.
No, I will provide with the judgments. I'll just give him now itself so that he can come back.
I'll be having entire holidays. She wants me to do the entire homework during the holidays.
Only two judgments he will have to deal with. I will give him. Mr. Ghosh will just take 5 minutes for that.
Judge has to deal with 19 of my judgments.
Yes. So therefore,
But the main
kindly give it in May.
crucial judgment in this case is at page 123 of the brief. That is Justice Banerjee's PIL judgment, which says that he was going to send our officers to jail. After that,
That's
all
the
the
most
letters have
crucial
started.
No,
And you are giving
that,
it away free.
That
when other people are
observation,
paying.
that observation was only, Your Lordship, at the ad interim stage where affidavits had not come.
My learned
So
friend
that
is more bound by that judgment than anyone else. But
এই বলো
It's an
কবে
open
কবে করতে
threat
পারবো বলো তো
to
এই
DVC and they've taken money.
বলো কবে
But on the reopening, any day,
I think it will be better.
you will have to.
Kindly, in May.
I have noted your facts. I remember because madam, there is no time on.
I'll leave it here.
Because you see, the motions are there now. You will be
I
taking
understand.
20 minutes the moment you start.
I'll try
Because
to be
no, I have not stopped anyone.
No, Your Lordships have never done that because
If you
we
want to
have taken
submit,
our
I'll-
own time to make our
because
submissions.
difficulties I have.
No, I completely understand. I completely understand.
প্রথম বুধবার কি আছে? বুধবার কি আছে? 11 June. 11 June at 15 minutes.
Yes.
11 June at 3. 3 নয়, 2:30 করে দাও, 2:45 করে দাও, 2:45.
শুনবো আগে আমার
2:45.
Your Lordship,
11 June.
11 June.
2:45.
And the judgments will provide to Mr. Ghosh earlier only so that he can come.
She also does not want to conclude now.
Years, Ms. Bhotoria has been
Now
in
the more or less is on the verge of conclusion.
Please not happening.
Everyone is now lingering it.
No, I've never taken time in
No,
this
no,
matter,
no.
Mr. Ghosh. I've always said.
So you insisted, so I took up the
Yes,
matter.
absolutely. Your
I
Lordship,
thought it will be over.
Your Lordships have always
Yesterday,
taken
on the
time
last
to
occasion.
give us.
Then you did not conclude it on that day. Today also, nobody can say that I can conclude it by this time. There may be
Because I
discussions,
had to
points.
deal with
Yes,
Mr.
yes,
Ghosh.
natural.
Yes.
Heard Ms. Bhuteria, learned senior advocate representing the petitioner. এটা বলো কবে ওটা রাখলাম বললো কবে list this matter in the monthly list of June 2025 marked ওই ডেটটা দিয়ে 2:45.
The date Your Lordship has given,
11th,
11 June 2:45.
2:45.
I'm extremely grateful. Grateful for the patient hearing Your Lordship has been
Yeah,
given.
it has to be concluded. You see,
Yes, absolutely, absolutely.
whichever way it
Yes,
goes, but
yes.
has to be concluded now.
Lordship, I'm actually
I'm carrying
extremely
this
grateful. Your Lordship
for a
has been
long
very
time now.
patient with us, Your Lordship.
My lord is keeping it on Wednesday. 11.
Yes, and difficulty.
11 June, Mr. Ghosh agreed. He had some.
আমি থেকে না এই তলায় ঢুকিয়ে দিও তো এটাকে না একটা অর্ডারের তলায় ঢুকিয়ে দিও ওই তো পেছনটা ঢুকিয়ে কল অরিজিনাল সাইট
Lordship, for item number 1 and 2, I appear on behalf of the petitioner in this matter. Lordship, we want to withdraw the writ petitions altogether because we have instructions that we want to, like the client wants to prefer an appeal in this matter. Your Lordship, if your Lordship may grant 3 weeks time to file the appeal, because the time to prefer the appeal has expired.
But before Lordship takes it up, at number 7 and 8, Lordship asked me to mention it for if there is any urgency. On the last occasion, I was, but only thing is, if Lordship can take these matters 7 and 8, I'm waiting.
Item number 1, I'm not for the
Lordship, I cannot hear your Lordship.
Assessment order is 29th March 2025.
Your Lordship, in this matter, the assessment order has been passed on 29th March 2025. Yes.
order has been passed.
So,
So there was no interim order.
you know, what is how many months? 60 days. Mr. Dudoria? Very well.
So 3 weeks time would suffice, your Lordship, in both the matters, 1 and 2.
Read petition দাও, read petition দাও। এটাই read petition।
May I file my opposition? I have to get opposition. Let it be kept on with the record.
Affidavit in opposition filed on behalf of the respondent authority stroke department is taken on record. Stop. Although the writ petition was filed challenging the show cause notice dated, challenging the show cause notice issued under section 148 capital AB of the Income Tax Act 1961 dated 25th of March 2023 in respect of the assessment year 2019-20 and the order under section 148 capital A within bracket D of the said act, of the said act dated 22nd April 2023 in respect of the assessment year 2019-20 and the notice issued under section 148 of the said act in respect of the assessment year 1920 dated 22nd April 2023 by the jurisdictional assessing officer. However, since in the interregnum the assessment order under section 147 of the said act has been passed on of the said act in respect of the assessment year 2019-20 has been passed on (29th March 2025) as would appear from the digital signature. Yes, madam.
Yes, your Lordship, 29th March.
Why have you written 25th March?
Lordship, in the list of dates.
In the prayer portion of the application, what have you written?
Yeah, inadvertent error it must have been.
Yes, 29th March 2025. And although a connected application had been filed challenging the aforesaid order dated 29th March 2025, which was registered as GA within bracket COM, what is commercial? COM bracket closed 1 of 2025. However, since the aforesaid order is otherwise appealable, the petitioner seeks to withdraw the aforesaid application along with the writ petition. Writ petition also, or only the
Lordship, the writ petition as well.
along with the writ petition, and would like to agitate all points before the appellate authority. It is submitted on behalf of the petitioner that since the application was pending before this court since 21st April 2025, and in the interregnum, the time to prefer the appeal has expired, this court may be pleased to permit the petitioner to prefer the appeal within a period of 3 weeks from the date of passing of this order. Mr. Sharma, learned advocate, appears on behalf of the respondents. Full stop. Having heard the learned advocates appearing for the respective parties and noting that the order passed under section 147. Madam, it's 147, Mr. Sharma? Yes, it's under 147. That the order passed under section 147 of the said act dated 29th of March 2025 in respect of the assessment year 1920 is an appealable order, and since the petitioner appealable order, and by order, and also noting that by order dated 3rd October 2024, this court had entertained the writ petition.
My lord, my reading.
No, entertained. There is an appealable order. Let the writ petition be dismissed as withdrawn. Full stop. Further, taking note of the fact that by order dated 3rd October 2024, this court had admitted the writ petition and the same was pending, and the connected application being GA commercial 1 of 2025 has been filed on 21st of April 2025. I am of the view that in the event the petitioner prefers an appeal from the order dated 29th March 2025 in respect of the assessment year 2018-19, petitioner prefers an appeal from the order dated 29th March 2025 issued under section 147 of the said act for the assessment year 1920 within a period of 2 weeks, madam.
Check 3 weeks.
Within a period of 3 weeks from date, the appellate authority, having regard to the pendency of the aforesaid proceedings before this court, shall condone the delay, shall hear out the appeal on merits provided, shall hear out and dispose of the appeal on merits provided the petitioner files an appropriate application seeking condonation of delay. Full stop. With the above, with full stop. Condonation of delay. The application accordingly stands disposed.
Lordship. Lordship, in the
writ petition and the connected application accordingly stands disposed of.
Lordship, in the next matter, the assessment order's date is different. It's 26th March 2020.
ডিসপোজ তো না হলে তো ডিরেকশনটা দিতে পারবো না। Unless I dispose it, if I only withdrawn, then nothing will be there. Next.
Same matter.
Lordship, in assessment order's date is different.
এই অ্যাসেসমেন্ট অর্ডারটা এখানে আছে। Assessment year, which year?
Lordship, the assessment year is 1920.
26 March 2025. Assessment year same.
1920.
Yes, sir. Lordship, 1920.
Grateful, my lord.
Grateful, Your Lordship.
ফাইলটা কবে করেছিল? 21 এপ্রিল এটা। ওটা 24 বোধহয়। Yes, call the next matter.
My petition, but my lord, I don't really see any purpose left in the application. I'll tell you, Lordship, why. My lord, this petition, my lord, was challenging the sale of one of the properties of Dunlop India Limited. But this is in Worli, Bombay, my lord, very valuable property. Our allegation was, as one of my lord, the creditors of the company, was that, my lord, this is visited by fraud. I had also obtained an injunction restraining ICICI Bank from creating third parties, because what had happened is the bank had taken over the property by enforcing its security charge, and thereafter the bank had sold the property to itself. Well, I had challenged that sale. Well, as a creditor, because well, if the property remains with the company, ultimately it will inure to the benefit of the creditors. Now, well, thereafter, well, the official liquidator has well, reduced my claim drastically. So, well, I'll have to stand in line 529 with all the other creditors. Well, I'll get virtually nothing. My machinery in the meantime, machinery which had been leased out to the company, Dunlop India, those have been sold, value has not been accounted for. Against
Sold.
that, yes, my machinery.
Sold by the bank.
By the official liquidator. But they have not said where the proceeds have gone, he does not know. Well, that is a separate matter. Now, this is the situation. I have also preferred an appeal against the reduction of my claim. That is pending an appeal. So far as this is concerned, I was pursuing this matter quite vigorously.
Judges summons to the.
But
I had mentioned this matter. I appear for the ICICI Bank. I had mentioned this matter because
get out of this.
I was the one who was.
What are you seeking here?
Well, I was seeking cancellation of the sale, but now even if the sale is cancelled, I will get nothing because my claim has gone down. I will have to stand in line with the creditors. My machinery sold. I am pursuing an independent appeal against the non-accounting for the value of my sale.
Direct this matter to go out of the list for the time being in that case.
May I just indicate one thing? I appear for the
ICICI Bank.
I appear for the ICICI Bank.
Yes.
Now, there are two orders of the Supreme Court, which covered the field. And by both, when Senior Mr. Shah complained that the properties are being taken away and things like that, the Supreme Court passed an order saying that asking me to deposit a bank guarantee for 520 crores and saying that if you deposit,
you have complied with.
Yes, that was in 2016. I complied with it. Thereafter, that bank guarantee was discharged and I was permitted to sell the property.
I'm not
pursuing. So, all that has already happened. So, today, a period of 9 years has passed.
No purpose. There's no purpose. My client's instructions.
What are the orders that have been passed? The order.
Yes. Release.
Which are claimed by me in the judges.
You enjoying any order here?
Yes, my lord. I was enjoying an order restraining the ICICI Bank from creating third-party interest on the property. If I don't pursue the application, Lordship dismisses, naturally that order will have to go. Honestly speaking, there's no.
They have sold the property.
They have sold the property to themselves.
After that, we don't know what has
happened. After
that, to Supreme Court's order, I was the secured creditor.
Where is that order passed by the Honorable Supreme Court?
That is, your Lordship will find it's an order dated. There are two orders of the Supreme Court. The first one is 12th February 2016.
Of this application?
Yes, Mr. Chakraborty, just point out the page number, please.
Yes. Which page?
Mr. Chakraborty, please point out the page number to his lordship.
21.
The instruction আছে তো আমরা কিছু করবো না।
Yes, madam, what do you have to say?
My lord, 12th February 2016 order, if your lordship has it.
I'll
highly
come back.
similar.
I'll come back to you. Just a minute. Use the microphone. He cannot hear you.
Coming up along with an application which has been filed by the officially, not in the office.
Okay.
That is CF 485 2020. There is the 4 properties that have already transferred, your lordship. We are seeking leave to file, take appropriate steps regarding those fraudulent transfers. This application, perhaps your lordship, required to be adjudicated along with that application, which we have filed. That is 485 of 2020. So if that application also comes up,
What is your prayer in your application, madam?
lordship, if my lord fixes next day, I'll come up with all that prayer.
Let the liquidator pursue the application. I don't have any
Let me
difficulty.
go through what is there.
Very
I'll allow you.
Because we have to adjudicate that matter also.
Let's, having heard the learned advocates appearing for the respective parties, let CA 485 of 2020 be listed along with this matter. কবে আসবে বলো? In the monthly list of June 2020. Monthly list আসো.
836, your lordship.
First Friday, your lordship, the assigned matter when taken up after the
First Friday itself. First Friday.
First Friday after the reopening.
Yes, immediately, because they'll be able to trace out the file and shoot it.
Be sure that you don't want to pursue the matter.
No, we have instructions. I remember your instruction. I'll just go through it.
Great.
Always very risky to say that I don't pursue it without a written instruction.
I have a written instruction. Yes, certainly. No, when you are submitting, I'm sure that you have checked up all this.
I am relying on the instructions received from my advocate on record.
I have a written instruction. You just keep it with you on that date. You just keep it handy on that date. Yes, I'll take it on record.
Please, your lordship. I have inquired with my learned friends. Tuesday. All both of them are
not possible. তারিখে এসে 14 তারিখে ওয়েডনেসডে যদি রাখি, ওয়েডনেসডে ডিভিশন বেঞ্চ আছে দেখো, না হলে তার পরের সপ্তাহে রাখবো।
Tuesday is not possible.
There's a holiday on the 12th.
Yes. No, your lordship, I'm saying next Tuesday.
Next Tuesday is not possible.
6th.
I'll keep it on the week thereafter. I'll keep it on 14th.
Lordship, the difficulty I had explained to your lordship earlier
That
is that
protection is there, always there, because you have got it. You could have chosen to prefer an appeal from that order. I had granted that limited protection. Beyond that, I said that I will not grant now. So whatever happens, happens. If anything happens, matter is pending before this court. They are appearing. And who are you appearing for? Yes.
I'm for all the response.
Mr.
Sorry, sir, who are you appearing for?
Respondent number 5 for
Yes. You are representing Mr. Sharma and Mr. Mitro. And you are there. And they are there before this court.
Next week will not do.
14th দাও, half an hour maximum.
That's
I'm fixing it at 3.
Yes.
Why I tell you? Half an hour, you will take half an hour? No.
I mean,
you tell me how much you will please indicate how much
within half an hour it will be done. That
because this is before the vacation, it not be possible for
I completely understand, but within half an hour it should be done. Lordship, if I have to just confirm Mr. Mukherjee's availability, your lordship fixes it. If there's a change, I'll come before your lordship. I'll just inquire right now. Because I had inquired.
15 তারিখে আবার ডিভিশন বেঞ্চ আছে জানো তো, তোমার লিস্টে লেখা নেই তোমাদের কাছে, ডাকো ডেকে জিজ্ঞেস করো 14th আছে কিনা।
Order, there's one mistake in the order, that affidavit was filed by not by respondent number 5 by the Union of India. It's written affidavit was filed by respondent number 5.
The order
It should be Union of India. So number 1. শুধু একজন ফাইল করেছে।
I'll correct it here now. I'll correct it here. Just a minute. So, ফাইলটা দাও, correct. 15th আছে তো?
14th.
But I can't accommodate you much more because you see there is a lot of difficulty.
I completely appreciate Lordship. Lordship, if there is any change, I'll come and indicate right now. Lordship gives me that liberty. Yes, Lordship, it will take me 2 months. 14th at 3 p.m.
That was over on that day. Everybody, so. In the order dated 22nd April 2025, it appears. Now, there appears to be a typographical error. Post up in page number 1, line number 2. In page number 1, line number 2, the word 5 as appearing after the words respondent number and before the words is taken on record be substituted with the word double figure, the figure 5, actually. Numerical figure 5, be substituted with the numerical figure 1. Let the aforesaid correction be incorporated in the order dated 22nd April 2025. Other portions of the order.
Excuse me, I'll just find out from Mr. Mukherjee's
Yes,
clerk.
yes. কয়টা টাকা লিখো না ওই ওরা এসে বলুক তারপর তার আগে হবে না ছুটির সময় রেখে দেবো ডাকো লিস্ট ডাকো আর ডাকো Mr. Sina, not in 5 minutes. So next day. Yes, next. There was an urgent matter. Someone was mentioning. Who is there? Yes.
14th is fine, Lordship.
14th, yes. 14th. List this matter as straightforward. List this matter as straightforward. List this matter on 14th as straightforward.
Lord,
List this matter on 14th. List this matter for further consideration on 14th. At কত বললাম 3 at 3 p.m.
My lord, with regard to item number 5, your lordship, if a date can be fixed, your
No,
lordship.
not now. Wait, I'll take it up. Only Mr. Sinha will conclude. I remember this matter. But for now, I will not take up any more hearing matters. This is not possible. I need to take up this other
That
matter.
side of the vacation, my lord, any date, if my lord fixes.
Let us see what happens. Let us see. Yes, yes.
7 আর 8 8 আর একসাথে আছে
Who is appearing other side?
Against the official liquidator 7 and 8. 8 is
paying-
my application.
And nobody.
Mr. Mukherjee is appearing on behalf of official liquidator,
Who is appearing?
Mr. Saurabh Kumar Mukherjee. So,
Yes.
Lordship,
not
kindly
today.
give me some preference because my entire 80 above 80 lakhs.
Next day.
Possession, they're holding over, not paying anything.
Monday. It will be there on.
It's better
Oh,
than-
Friday. These are Friday.
But vacation is coming. That's why I'm requesting for some.
What will happen? You get some money before the vacation. This is a hearing matter. I remember.
But no affidavit has been filed for 5 years.
Complete your affidavits. I'll place it for hearing. Yes.
Lord, may I please
Yes,
mention,
Answers expired.
Yes, sir. Yes, sir.
my lord, item 1, 2, 3, 5 of the combined monthly list.
Yes.
My lord, this has been specially assigned to your lordship.
Yes.
My lord, in your lordship's list, my lord, it says the matter has been delisted. My lord, this pertains to a member of the bar whose chamber has been ransacked by some goons. My lord,
Listed. Why?
my lord, we do not know, my lord. Your lordship, last order, my lord, is of 7th of March.
Cannot delisted.
Since caveat, my lord, was on record
Appellate side. You have to mention in the morning. Mention Monday.
Monday. I'll come back, my lord.
It has been delisted. You're saying it has been cannot delist হয়েছে দেখো প্রসেনজিৎ
It's in the heading of your lordship's list. It says this particular matter has been
maybe
delisted.
this is not determination is no longer with me.
No, my lord, this has been specially assigned to your lordship. Because this was with Justice Basu, since it's a matter of the member of the bar, and perhaps the judge knew the concerned lawyer, my lord,
Let him come.
it was released.
প্রসেনজিৎ কই ওকে ছাড়া হবে না তুমি বের করো তো লিস্টে ওই যে হি নোজ why it has been order আছে কোনো Have you checked up the file, whether any order is there in the file?
My lord, there is an order passed which I have in my hand, your lordship may
order.
consider. It's at the motion stage, my lord. We were seeking a stay of the impugned order. Your lordship was pleased to, my lord, direct us to serve. We've served. Affidavit of service is ready. There was a caveat. None appeared.
Oh, when I was taking up the 227.
My lord, this is when your lordship, my lord.
227.
No, this was before Justice Basu. And then, my lord, Justice Basu was taking up 227. And then his lordship was pleased to release the matter on personal grounds. So that is when, my lord, it went to the learned Chief Justice, who assigned the matter to your lordship.
Then why the direction is there? delist করা আছে কেন?